Good morning and welcome to the 23rd meeting of 2025 in Session 6 of the Equalities, Human Rights and Civil Justice Committee. We have no apologies this morning, and our first agenda item is to decide to take whether item 4 whether to take item 4, which is consideration of our work programme in private. Are we all agreed? We're all agreed. Our next agenda item this morning is evidence taken on the children withdrawal from religious education and amendment of UNCRC Compatibility Duty Scotland Bill. This is our final evidence session on the bill, and I therefore welcome to the meeting Jenny Gilruth, Cabinet Secretary for Education and Skills, and the Cabinet Secretary is accompanied by Lewis Hedge, Deputy Director of the Curriculum and Qualifications Division, Joe Smith, Children's Rights Reporting and Monitoring Team Leader, Denise Mackay, Deputy Director, Children Education, Rights Incorporation and Disclosure, and Sarah Booth, lawyers from the Scottish Government Legal Directorate. You're all very welcome this morning. Thank you for joining us. I would firstly like to invite the Cabinet Secretary to give a brief opening statement before we move on to questions.
Thank you, Convener. Good morning to committee members. I welcome the opportunity to give evidence this morning on the children withdrawal from religious education and amendment of UNCRC Compatibility Duty Scotland Bill today. The bill, as members will know, has two key purposes, namely to strengthen children's rights in decisions about religious observance and religious and moral education, and to clarify the legal duties for public authorities under the UNCRC Incorporation Scotland Act 2024, that is in situations where provisions under Acts of the Scottish Parliament could conflict with UNCRC obligations. This bill is deliberately very focused in nature, and it is intended to address priority concerns within the current parliamentary session. It is also a technical bill to address two specific but separate purposes as set out in Parts 1 and Part 2 respectively. Now, as members will know, religious observance and religious moral education are two very distinct but important aspects of Scotland's education system. Religious observance supports pupils' spiritual development and helps to build a sense of community and belonging. And religious and moral education allows pupils to learn about different religions and belief systems and promotes understanding about them, as well as exploring ethical questions. Religious and moral education is one of the 8 core curriculum areas within Curriculum for Excellence. Sections 8 and 9 of the Education Scotland 1980 Act provide for the long-standing parental right to withdraw a pupil from religious observance and/or religious and moral education. Guidance on religious observance notes that pupils' views should be considered within the withdrawal process. Currently, however, there is no requirement in legislation to do so. The decision rests entirely with the parent. The changes this bill would make in Part 1 therefore provide a legal right for the child to be consulted in the withdrawal request initiated by their parent. The aim is to provide legislative certainty that children and young people's views should be taken into account when parents are exercising their right to withdraw their child. It does not introduce an independent right to withdraw for the child or alter the parent's long-standing right to request a withdrawal. Without these changes, pupils may be denied these aspects of their education against their wishes, and their rights under UNCRC Articles 12, 14 and 29 may not be upheld. Now, I'm conscious of the very wide range of views on this issue that have been expressed to the committee. Our public consultation also showed a wide range of views on religious observance and religious moral education and the exercise of parental and children's rights in the context of learning. As such, the consultation responses reinforce the decision to chart a middle course for the changes on the spectrum of stakeholder views. Our approach, therefore, aims to support alignment with the UNCRC, while also balancing 3 key considerations of parental rights, stakeholder views and the practical implications for schools. Now, turning to Part 2 of the bill, the UNCRC Act places a legal duty on public authorities not to act incompatibly with the UNCRC requirements when carrying out functions under Acts of the Scottish Parliament. This is a key part of the Act. It allows children and their representatives to challenge decisions and seek redress when they believe their rights have not been respected. Nevertheless, a public authority could face a legal dilemma in the event that, in the future, it is required by an Act of the Scottish Parliament to act incompatibly with UNCRC requirements, and where that requirement cannot be interpreted in a way which is compatible with the UNCRC. The bill, therefore, makes a limited and technical amendment to the 2024 Act to ensure that this framework operates in a way that is clear, fair and practical. It introduces an exemption for public authorities in the event that a conflict between an Act of the Scottish Parliament and the UNCRC Act arises. This exemption means that a public authority would not be forced to choose between breaching the compatibility duty or stopping the delivery of an essential service altogether. And that accountability is directed at the incompatible legislation where the source of the problem lies. The exemption therefore ensures legal clarity and continuity of essential services, protecting children from avoidable disruption or harm while action is taken to consider and address any legislation that is found to be incompatible. This change has been framed in such a way that it reflects the safeguards that exist under the Human Rights Act and which has long been understood as necessary to avoid penalising public authorities for acting in accordance with legislation. But the exemption we are proposing is narrower in scope and will apply only where there is no discretion to act compatibly. I welcome the broad understanding shown by many stakeholders, including Together, the Children's Commissioner, UNICEF UK, of the rationale for this approach, while recognising that some concerns have also been raised. And I hope the detailed letter that I sent to committee during recess has helped to address these points, and I look forward to discussing them further today.
Thank you, Cabinet Secretary. As you alluded to there in your opening statement, there have been a wide range of witnesses that we've heard from over the last few weeks, and for varied reasons, they have been quite critical of the bill. And I'm wondering, what is your response to that? And are there any reassurances that you can give these witnesses that this bill is necessary in its current form?
So I think I've been struck by the evidence the committee has taken, and I was looking again yesterday at the evidence sessions the committee held, and there are a wide variety of different views on these subject areas. I've been quite clear of the rationale for why we need to act in relation to these issues. And part one, of course, as I've set out, is about the issues that have been raised about the current legislation on RO and RME and the Scottish Government's UNCRC obligations. So on the one hand, we could go to the independent right for withdrawal, which might appease some stakeholders that you've heard from. It won't appease them all. So I've had to take a pragmatic approach that maintains the parents' right to opt their child out of religious education or religious observance. That's maintained, but also puts beyond doubt the views of children into law. And at the current time, that is not the case. And there is an issue there in terms of how children's views are listened to or not. So our expectation would be, and I was discussing this only yesterday with the Church of Scotland and the Scottish Catholic Education Service, that actually head teachers do this all the time. They speak to parents and carers, they engage with them, and certainly in my own experience, that is quite a natural part of how schools would engage with home, and head teachers are good at having those conversations, at listening to views and at balancing that. I do think, though, the legislation is required for the reasons I've set out. We had to chart a middle ground. Doing that means looking at how you can bring stakeholders together. And I think reflecting on the evidence the committee has taken, most of the stakeholders you've heard from have been supportive of the bill being introduced. So I think from that perspective, that's welcome, and we'll continue to work with those stakeholders as we make progress in terms of the legislation.
That's great, thank you. We now have questions from Paul McLennan, please.
Thank you, Convener, and thanks, Cabinet Secretary. I suppose in some of the evidence we've taken, there's kind of varying views, and kind of two questions wrapped into one here, and it's what's the Government's current understanding of how the right to withdraw from RO and RME currently works in practice in both denominational and non-denominational schools, and how aware are parents and children that there is a parental right to withdraw from RO and RME?
So, in terms of the second point, if I can come to that at the start, I was quite struck by some of the evidence the committee heard on this point, because it was raised by a number of stakeholders that parents aren't perhaps aware of this legal right that's existed, obviously, for many, many years. And I think through the guidance that will sit alongside the bill, if it is passed, we can help to provide further clarity in that regard. And I know, I think it was from, it may have been Connect, it was one of the parental organisations the committee had taken evidence from. They talked about, for example, disparate approaches to school handbooks, that maybe not being communicated in the way in which they would expect. So I'm happy as Cabinet Secretary to reflect on that. I think the passage of the bill in itself will draw parents' attention to the fact they have this right, and that will help to foster better understanding. But again, the guidance, which I think has also been raised by stakeholders in committee evidence, can help to provide further clarity in that regard in terms of parental rights. And in terms of the 27, how the kind of guidance works at the current time, we have very low rates of withdrawal. I think committee took evidence from Barbara Cooper on this, from the Scottish Catholic Education Service. I spoke to Barbara yesterday. We're looking at very low percentages in terms of withdrawal rates. And Lewis might want to give you the specific numbers to hand. So I think it's 0.59% withdrawal rate overall, 0.56% from religious observance and 0.19% from RE. Is that correct, Lewis?
Based on that sample.
So very low rates at the current time in terms of how it operates at the current time in relation to that practice. We did supplement that back in 2017. I think the committee heard evidence on that point. That was published by Education Scotland, and I spoke only yesterday to the Church of Scotland on that point. We're supportive of the guidance. So I think there's support at the current time for the way in which we approach this issue. I have given the committee rationale as to why we have to slightly adopt our approach, but I think in broad terms stakeholders have been supportive of this nuanced approach, and I'm more than happy to work with them as we progress through this. I recognise, though, going back to the member's original point, we are talking about a very small percentage of children overall.
Can you just a quick follow-up if that's okay? It's more maybe the role of COSLA in this, because I think we kind of heard from different local authorities have different kind of views in terms of that. So I suppose what's the overarching, not view of COSLA, but where do you see the role of COSLA in this to make sure that there's a uniform approach? I know they're slightly different in terms of how local authorities look at it, but almost making sure that there's that awareness out there.
I think this is a very technical and focused bill, but the committee has quite rightly probed some of the issues in relation to the 1980 Education Act, and I'm regularly asked about these things in the Chamber, as members will know, in terms of how that interacts with ministerial responsibilities and actually the statutory responsibility for the delivery of education. It does not sit with ministers, it sits with COSLA and local authorities. So to have greater consistency, you need to have COSLA supporting and working with local authorities. We have different approaches to delivery of education across Scotland. We also have it within local authorities, within schools. So that's because Curriculum for Excellence is meant to be about local delivery. It's meant to be about empowering our teachers to look at how they deliver education in their context. I think there have been elements of evidence the committee has heard, probably from the Children's Commissioner and others, around consistency on reporting requirements and things like that. I'm happy to look at those issues in detail. One of the things through the Verity House Agreement we established was the Education and Children's Assurance Board, which brings together ministers and local government to talk about that assurance work, to say, to look at how we can drive greater consistency. So I'm happy to take those issues away, because I think there's an ask there in terms of how education is delivered. There are wider, perhaps, questions around about the 1980 Act, which I don't think this 5-page bill is going to resolve. I think are very interesting, though, in the context of wider work that we might have in reform space. And the committee will know about that work in terms of curriculum improvement, how we're looking at reforming the curriculum. I think committee might have heard some evidence on that from some previously.
Okay. Thanks, Cab Secretary. Thanks,
Okay, thank you. We'll now go to Miriam McNair, please.
Thank you, Convener, and good morning, Cabinet Secretary and your officials. Just sticking on the withdrawal rates there, obviously we've heard concerns that the withdrawal bill may cause additional pressure for schools. Throughout the evidence session we touched on earlier on, we heard that withdrawal rates for loans, there's actually some schools that don't have any. Yeah. If this is agreed, what's your thoughts as we move forward on this? Do you foresee any additional pressures placed on schools with the changes?
So, colleagues will have looked at the financial memorandum, and that's not our understanding in terms of how this will operate in practice. And I think it is worthwhile saying that these changes effectively align the legislation with the existing guidance. The guidance at the current time, to our mind, does not provide that protection, so that's why we're amending it. But the legislation rather. But we don't expect there to be increased workload as a result of this. And I think I just remind members, I know you've taken extensive evidence on this, but we're not removing the parental right to withdraw. What we are introducing is a child's right to opt back in. So if anything, we will see more young people opting back into religious observance and to RME, for example. So we don't expect that will drive a workload in that regard, because we could have fewer young people opting out, as has been the case in the past. Although I would link the member's point to the points raised by Mr McLennan, because I think I am pretty sympathetic to the views that have been expressed to committee that not all parents are aware of their legal rights in terms of the 1980 Act. And I do think that us taking this legislation through will help to draw attention to it, but as will the updated guidance. And that will help to inform different approaches perhaps to policy practice in schools and communication with parents. And, I think committee heard some evidence on this point from Connect, which is the National Parents Organisation, which Scottish Government funds. And I'm happy to engage with Connect on those issues, because I do think there's an issue there in relation to parents being aware of their rights in terms of withdrawal.
That's helpful, thank you. That's me.
Okay, thank you. We now have questions from Maggie Chapman, please.
Thanks very much, Convener, and good morning, Cabinet Secretary and officials. Thank you for joining us this morning. I've got a couple of questions on slightly different but I think related points, sticking with part one for now. Many stakeholders have said that the bill conflates religious observance and religious and moral education. And I know that that is the case in pre-existing legislation, but we've heard quite a lot of very, very clear evidence and very, very strong support for the view that RME should not, there shouldn't be the possibility of opting out of RME because of the value it has for our society, for that role of education. Can I ask, why did the government not take the opportunity in this legislation to make that distinction in law and say, actually, RME is core to our curriculum and we won't have young people being opted out, whether it's them or their parents doing that, because it is one of those fundamental areas of our education?
So going back to the evidence committee has taken on this, and I've seen the views from a number of stakeholders on this. I know that colleagues around the table will be aware of the policy memorandum, which we essentially looked at this issue. We have diverging views on it, I think it's fair to say, as the committee has heard, on a number of topics that this bill considers. So we looked at removing the right to withdraw from RME for parents as part of those changes. That's been done for the equivalent curriculum area in Wales, and in particular we looked at the benefits of RME as an academic discipline for all pupils, as well as its role in helping to promote community cohesion, and I think that's quite important. But given we had so many different concerns raised about restricting parental rights in stakeholder engagement and also in consultation responses, we decided at this time there wasn't sufficient support for a change. And I think the issue the member speaks to in terms of putting, I think Ms Chapman can correct me if I'm wrong, but she made a point around about putting RME on a statutory footing. That's not how the curriculum is delivered in Scotland at the current time. So we have curriculum for excellence, we have our 8 curricular areas, but we don't mandate certain parts of the curriculum. And I think if we were to do that, that would be a much bigger piece of legislation than what is being proposed at the current time, which is a technical bill in nature, it's very focused. But I'm not diminishing the points that Ms Chapman has made. I think there are important issues in that regard. I discussed this yesterday actually with Scottish Catholic Education Service, and I'm more than happy for us to look at some of this work, for example, through the curriculum improvement cycle, which I mentioned to Mr McLennan earlier on. The curriculum improvement cycle, as colleagues may be aware, and usually I'm in front of the Education Committee talking about this, is essentially looking to update our whole approach to the curriculum. It's being led by teachers, and I'm more than happy to look at these issues in terms of Education Scotland's role and providing that greater clarity, as I know it's an issue that's been raised by evidence sessions.
So just to be clear, I wasn't suggesting that RME gets put on a statutory footing, okay. But I think there is quite clear agreement that RME is so distinct. And I mean, you said yourself in your opening remarks, RME and RO are distinct. Yeah. RME is a core part of curriculum for excellence. Why not take this opportunity to separate them in law? I'm not saying put one on statutory footing. I'm saying, as CFE suggests, this is core to our understanding, to our education, to the development that young people have about how to be citizens, how to interact with, how to learn about, how to understand other faiths, other belief systems, ethical questions. Why give people that option to withdraw from that, given that they... And some of our witnesses have suggested that could be the thin edge of the wedge. You know, if people don't like some of the science courses, can they opt out of those then? So you know, these are the kinds of the questions that we've been wrestling with during the evidence gathering, and I'm just curious as to why the decision not to quite clearly separate RO and RME was taken, not necessarily putting one or other on a statutory footing.
So I think it's important to remind committee that we're not proposing that we provide young people with an independent right to opt out. If anything, this is about actually providing them with the right to opt in, because opt out can only be driven by parental decisions. So we're not changing that. And
yeah, we'll come to that, because okay. I think the question about that as well.
That kind of principle of Scottish education goes back to 1872. So a time when RME in our schools, as members will know, was very different in nature and far less objective. So I think we need to be careful here. there are legal provisions currently that protect the right to opt out for parents for RME and for RO. They don't apply to any other aspects of the curriculum. So we need to be clear about that. So when we talk about other aspects of the curriculum, that's not what this is about, and I think we should be very mindful of that. But Ms Chapman asked why we've not done that, and I go back to the policy memorandum. We did look at this, and I would encourage members to look at that if they've not already done so. There are lots of views on this. Finding alignment on this issue would be very difficult. It would not present, for example, a 5-page bill to this committee. It might take a lot longer. But I am not suggesting this is not something we will come back to in the future. I think there are other ways in which it can be considered. And indeed, I touched on this only yesterday in my discussions with the Church of Scotland and with other stakeholders. So I'm happy for us to look at that issue in its totality and in the round. I don't think you can... I don't think we'll be able to find a route through the issues that Ms Chapman has raised today in a short technical bill as is proposed at the current time, for all the reasons that we've seen in terms of our consultation in relation to stakeholders. But I don't know if Lewis or officials want to say more on that point.
So I suppose it's the scale of the change, as the Cabinet Secretary has outlined, in terms of the size of the bill and the change that this would represent. And I think when we looked at it also just in terms of the data that Cabinet Secretary shared earlier, kind of 0.1% of pupils withdrawing from the RME component as opposed to RO, it feels like in practice there isn't sort of a huge problem to solve here in terms of people kind of not getting access to the RME element of the curriculum.
Okay, thank you for that. I think there'll just be different views on whether that could be done with this bill at the moment. But linked to that, I suppose, given the concluding observations made by the UN Committee on the Rights of the Child, it's twice suggested in 2016 and 2023 that children should have the right to withdraw from collective worship, from RO, not RME, from RO. Can you just give us a little bit more detail as to why you've not gone down that route to put us to enact those recommendations that we've had twice in the last 9 years?
So forgive me, Ms Chapman, but are you talking about the independent right to withdraw?
Yes.
Yes. So I think, as I intimated in my response previously, we could have adopted that route. We might have appeased some stakeholders that you've heard from. We would not have appeased them all. The government has taken a pragmatic middle ground here to try to work through balancing parental rights. And in recent years, as members around the table will know, there have been issues around about parental rights in education and how parental views are listened to. I'm very mindful of that, and I think that parental rights to withdraw in relation to RME and RMO is important. We're not proposing to change that. But what we are proposing to change is that children's views are taken cognizance of. At the current time, there is no real legal requirement for that to be done. There is guidance, but essentially children can be withdrawn at the behest of their parents. We think it is important that that is put beyond legal doubt, and that's what the bill will do. It will ensure that children's views are listened to, and there is a discussion about withdrawal, for example, from RMO, or whether that be from RME too. So we charted a middle ground. I absolutely accept Ms Chapman's points that this will not appease all stakeholders. It may not appease her. But in doing this, I have to balance the views of other stakeholders against those that may be on a different side of the argument. And I think we have to come to a collective view on this, because the bill itself is fundamentally about strengthening children's rights. And at the current time, I think there is a question around about how children's views are listened to. So this puts it beyond doubt. And I think the updated guidance that we'll publish alongside the bill will help to provide a bit more clarity to schools in that regard, which I think was the important point that Mr McLennan was making earlier.
Thanks, Cabinet Secretary. I suppose in coming to that middle ground, there's a risk that actually you don't appease anyone. You don't make anybody happy by
Ms Chapman, so I'm not sure I agree with you on that.
I mean, I do think it's interesting that you in your final remarks there you talked about strengthening children's rights, and yet you aren't proposing to give them this independent right. But I accept your position is where you are just now. I suppose in a slightly different space, one of the concerns, and this might be this might have impacts on the numbers, on awareness, which I know other members will come in on, but there was concern around whether young people might feel othered by either by any of the conversations in this kind of space, by being able to opt back in if they have been withdrawn or not. And we heard some quite concerning evidence, I would say, from Leah Rivka about some of
I saw that.
quite frankly, completely inappropriate comments made by staff members. And I just wonder how you see, whether it's in guidance, whether it's in additional training, how do you see us dealing with potential othering or concerns about othering, and then the inappropriate comments that clearly are being made, whether we like it or not.
Yeah. So I read the evidence that you're referring to, and I was quite shocked to read it, and that should not be happening in our schools. But in terms of that othering, so I had a helpful discussion, as I mentioned, I think earlier with the Church of Scotland yesterday on this, and the representative from the Church of Scotland is a former head teacher and a former RME teacher, which is helpful. But he made the point that head teachers are very good at dealing with issues like this on a daily and weekly basis. And we need to trust our head teachers at responding to these issues as and when they arise. I think one of the other issues that committee alighted on was the idea that this might create conflict. But the committee also heard that conflict already exists in the current system. So we have a legal right to withdraw. It's about how that's administered. This is about people. This is about relationships. We don't want our young people to feel othered when their parents choose to opt their child out of religious education. That is a right that they are entitled to. So schools are good at managing this, I think, at the current time. I've seen some of the anecdotal evidence that the committee has taken, but I go back to the point I think the Church of Scotland made to me, which is about trusting our head teachers. However, I do think there are opportunities here through the guidance, and we'll obviously continue to engage with schools. We'll listen to stakeholders through the passage of the bill about if there are ways in which we can strengthen that to provide greater reassurance. I'm more than happy to do that. I don't think anyone around the table today, regardless of their position on the bill, would want a young person to feel like that in our education system. We have an inclusive approach to education in Scotland. I think it's important that is protected.
And so, no, I thank the Cabinet Sec for those comments. I suppose it's just, it is a concern if young people are feeling othered, or won't have these kinds of conversations with their teachers. How, and maybe this goes back to why RME is so important, how we foster that inclusive culture of conversation, of understanding, of acceptance of difference. And I wonder if the Cabinet Secretary thinks that there is more that we can do. Maybe that's not about legislation at all, but is about building that sort of culture of inclusivity and acceptance. And are there other things that we maybe need to be looking at elsewhere? This committee has looked at, public sector equality duty that local authorities and therefore schools have. How are we joining the dots on this, essentially?
So I think we are, but I don't think committee's taken evidence from Education Scotland. I was just thinking this morning, we actually have a national senior education officer, I think it's still Joe Walker from when I was last there many years ago now, who leads on RME and RMPS rather, RO at national level. We also have a national advisor who's working just now with our faith-based organisations and across the country in terms of how we update the curriculum. So it may be that the committee wants to write to Education Scotland or engage with them on those. I'll leave that up to the committee. But I think there are important points that Ms Chapman has raised. But of course, the bill does require head teachers to inform pupils of a parental request. So we would expect there to be a discussion and a conversation. We don't want young people to be othered. At the current time, though, children can be withdrawn from religious education and RO against their wishes. Yeah. We don't think that is tenable. So we need to look again at how we deliver on children's rights. I absolutely accept that Ms Chapman may be persuaded by the views of others that we need to go much further than we have. I could have gone there. In doing so, I would not have the support of other stakeholders. So I have to, as Cabinet Secretary, try to bring together parties on this. And I think as the bill makes progress through Parliament, there are ways and opportunities and means, as the member has alluded to actually through guidance, that we'll be able to do that and provide greater reassurance to.
Okay, thank you. That's helpful. Thank you.
Thank you. We now have questions from Tess White, please.
Thank you, Convener. Good morning, Cabinet Secretary.
Good morning.
Just two questions. The first question is, when we actually listened to what the stakeholders were telling us, and you've talked yesterday to some of the witnesses who came in front of the committee, it was fairly unanimous that this is going to create conflict between parents and children. And in relation to that conflict, it could be one of the unintended consequences. So it's almost as though the state is stepping in, where you yourself have said that head teachers really manage this nuance. I think you said head teachers do it all the time. So why should the state come in when it's not a problem anyway for head teachers?
So on the point about conflict, I think I mentioned this in response to Ms Chapman. So I was quite struck by this because actually if you look at the responses, I think, from the Children's Commissioner, from Together, from the EIS, and broadly from a number of stakeholders, they are supportive of the kind of general principles behind the bill. But when we get into it, there are other issues in terms of how that's enacted. And I'm more than happy, as the bill progresses, to listen to those views and to seek to try and find a compromise, as Maggie Chapman mentioned. I'm not sure they would be unanimous on that point of conflict, because the committee also heard that conflict exists just now. So, for example, if a young person just now does not want to be withdrawn from religious education or religious observance, they have no legal right to say no to that. So parents' views on that rule absolute. We don't think that's right in terms of where we are with the UNCRC. So we need to balance that. I don't think this is about the state, actually. I think this is about us listening to children and young people. So I actually don't really necessarily agree with that point. This is about listening to the views of children and young people. Schools already do it. I would agree with Tess White that that already happens. There should be conversations. But the law, as it currently is, does not stipulate that it needs to happen. So to put that beyond reasonable doubt, that's essentially the kind of approach we've taken. And as I say, we could have gone much further. We could have had a much more interventionist approach, which I incidentally don't necessarily think Tess White would have supported, which would have been an independent right of withdrawal. I've not supported that for all the reasons that I've just discussed with Maggie Chapman. We have to chart a kind of pragmatic approach here in listening to children's rights and in maintaining parents and carers' right to withdraw their children from RME and RO, which of course is set out in statute. We're not proposing to change.
Cabinet Secretary, we're spending a huge amount of time as a committee, you're here today, looking at a technicality.
Yeah.
The sample size is so small. And yet we're doing this huge piece of work, a bill going through Parliament, when head teachers, none of our witnesses said there's a problem. It just seems to be a sledgehammer to crack a nut.
Well, I'm not sure I would use that as the description. It's a 5-page bill, so I hear that this is causing the committee lots of additional work. I've taken other pieces of legislation through the Parliament that are much more extensive than this. This is a technical bill. There are lots of different issues that have been raised by committee in terms of the evidence sessions that have been heard. There are lots of different views on this. I'm happy to listen to those views, to engage with stakeholders. I've got to chart a route forward. It may not be top of teachers' list just now in that regard, but we do need to reflect better how the UNCRC interacts with that right to religious withdrawal, rather parental right, and balance that with the rights of children as well. So it's a technical change. I appreciate this is taking up time for the committee. I apologise for that. But we are where we are in terms of the parliamentary year. So,
and that's not the point. The point is, Cabinet Secretary, that nobody can see why we're doing this. The last few weeks we've had witnesses coming in, Church of Scotland, Catholic Education, Scottish Human Rights Commission, and we're all scratching our heads on this.
OK, so the specific issues are about the UNCRC. So it's Article 12, the right to be heard, and Article 14, the right to freedom of thought. So Part 1 of the bill puts beyond doubt the position in Scotland by introducing a legal requirement to consider pupils' views. So this is about how the UNCRC interacts with religious withdrawal at the current time. That's why it's happening. I absolutely appreciate it may not be top of the stakeholders list that you heard from, but the reason we need to look at these issues, I think, have been pretty well discussed in committee previously. And
then one final question is, will you be giving extra support to head teachers and schools to manage this when conflicts arise and students have to be placed and additional support given?
I'm more than happy to look at that. I go back, I think, to the points that were made to Marie McNair. We need to remember now that this bill is not about more children, to our mind, coming out of religious observance or RME. It will actually see an increase, we think, in children opting in, because this is putting into statute children's rights to opt back in. We don't change parental views here, but we're saying that more children might be in. So I don't necessarily foresee there to be an increase in that regard of people withdrawing, but I'm more than happy to talk to, for example, School Leaders Scotland, who are the kind of professional association for head teachers on these issues. And if there are areas we can look at and guidance, absolutely more than happy to give that support.
Thank you. Back to you, Convener.
Thank you. We now have questions from Pam Gossel, please.
Thank you, Convener. Good morning, Cabinet Secretary, and good morning officials. Cabinet Secretary, this is a question I had asked one of the previous panels. Religious education is one thing, but do you believe this could be extended to other subjects? As you may know, I have introduced a Prevention of Domestic Abuse Scotland Bill, which makes domestic abuse education at schools mandatory, but would give parents the option to withdraw their children from such courses. Similarly, we have heard that primary schools are working with controversial groups such as LGBT Youth Scotland, with many parents expressing concern over what their children are being taught. So, Cabinet Secretary, do you believe that this bill will end up setting a precedent whereby children as young as in primary school are in a position to override their parents, even when it comes to controversial subject areas that could harm children?
I thank Ms Gossel for her question. I was actually discussing her bill with officials this morning. It may give her some joy to know, but I'm interested in her bill because of the introduction of this proposed mandatory element in terms of education. And this goes back to the point that Maggie Chapman was making. That's not the approach we have to education in Scotland at the current time. I'm interested in it because I'm regularly told as Cabinet Secretary, we need to mandate things. You need to mandate banning mobile phones. You need to mandate behaviour practices. And as I go back to the points actually that were made by Paul McLennan, that's just not how our schools are run in Scotland. So there are bigger questions here in terms of the 1980 Education Act that I think the committee is chipping at. I'm not sure we're going to resolve them in a 5-page bill, but that is not to say I don't think they're important, because there are question marks here around about which should be, which parts of the curriculum should be mandated and what should that look like, and how's that delivered in a rural context? What does that look like in an urban environment where we've got perhaps different approaches to staffing arrangements? So Ms Gossel will obviously be taking her bill through. I'm more than happy to meet with her actually and talk to her about the specifics on it. I am interested in it, and I'm very interested in it about how we can strengthen some of that approach to domestic abuse and really in particular support children who might be experiencing that at home. In terms of what is taught, I had seen some of the evidence. Ms Gossel had her line of questioning to other other witnesses rather on this. In my experience, I suppose this goes back to the point I was speaking to Tess White about. This is about parents engaging with their head teacher, speaking to them. The only legal requirement at the current time in terms of an opt-out applies to RMO and RO. RME rather and RO. So it doesn't apply to other parts of the curriculum. We're not proposing an extension in that regard today. And I think in terms of children's views, I know the committee had again probed some of these points around about capacity. We would always expect as a government, and I think this is already set out in the guidance, that there are discussions with young people about their views. So if a young person's mum or dad or carer wants to take them out of RE and RO, there's then a discussion with the young person about how that happens. Now, at the current time, that would be good practice, but it is not set out in statute that that would happen. So we need to make sure that children's views are also listened to in that discussion. That's what this bill's about. I appreciate the members made other points there in terms of other organisations. I don't necessarily share them, but I think that's a wedge issue that's separate to where we are in terms of this bill, which is quite technical in nature and is very focused on religious education and religious observance.
Okay. No, thank you for that, Cabinet Secretary, that clarity, because we do know that when the gates are open, precedents are set, and basically people go back to that and start looking at other subject areas. But it's great to hear from you today that this is about this bill and it won't be about precedents set for other areas. I have another question. Cabinet Secretary, there has been some concern about schools having to decide on whether a child is capable of forming a view on religious education and or observation. Yeah. This is something I asked one of the previous panels last month. I raised the fact that children under the age of 18 cannot serve as jurors or get credit cards and many other things they can't do as well. With this in mind, how will teachers be able to determine that a child is mature enough to make a decision about their education and whether or not the parents are right in withdrawing their child from religious education or observance? Is it really a decision that teachers should be making? And are you able to explain the Scottish Government's position on the approach taken in this bill? And I do understand you have obviously answered to Maggie and to Tess, but I just think that putting teachers in that position, I feel, is something that teachers already have a lot to deal with right now, and putting them in that position. How are you going to balance that the teacher can actually understand what a child is capable of? I also asked in one of the sessions was that it could be 2 children from one family, and you talk about children's rights here. One child, the teacher may think that, that is capable of making a decision, and another is not. So how do you balance those rights then of 2 children?
I might bring in officials on this. I don't think we're proposing that teachers get to decide. This is about young people's views being listened to. And at the current time, essentially, they don't need to listen to young people's views and decisions about withdrawal. We don't think that goes far enough. And obviously, we've had a discussion as to why that's the case. So it's not a decision for teachers at the current time. It remains a decision for parents and carers to withdraw their young person from RO and RME. All we are saying is you need to speak to the young person about their views on this. Now, in terms of teachers and managing this, they're already dealing with these situations. It's already happening. So I don't think this is necessarily new. These things are dealt with. And as committee has heard, I gave the statistics earlier on, we are talking about a tiny percentage of pupils. We're not talking about lots of young people here withdrawing from religious education. So it's already the case that we have a small number of pupils who withdraw. As and when that happens, good practice at the current time, and as is supported by the national guidance, would be for head teacher or the teacher to have a discussion with mum, dad, parent or carer and the young person and listen to their views. But they don't have to. So the bill puts that beyond reasonable doubt. But I don't know if officials from a legislative point want to add anything further to that perspective. From my understanding, though, this is not a decision for teachers to make in terms of capacity.
Thank
Elise,
you.
Do you want to come in? Sorry.
Certainly. The bill, as it stands, sets out a statutory presumption that children have capacity. So if you're in the section in Part 1, which is the new 9A, sets out that the children will be presumed capable of forming a view unless the contrary is shown. So, and then for the teachers themselves, they will their job will to be have regard to any views expressed where they take account, having taken account the pupil's age and maturity. So I think for the teachers, they will be able to comply with that and be able to take account of those views, and they have the benefit of having a presumed capacity to start with. So the anticipation is, if we're wanting to create a scheme where the children's views are heard, we have to ensure that those who are listening to those views understand the capacity issue. So you start with the presumption, which is what the law has done. And we're confident that the education system as it exists at the moment and the way that the teachers are in the classrooms at the moment will understand the abilities of the children that they're teaching and will understand their sort of ability to understand the subject matter that are being spoken to. And we think that the bill addresses that point.
And if I could just supplement that, because I'm sympathetic to the points Ms Gosel made about supporting teachers and how they deal with these discussions, because of all the points I think that Tess White made. So the statutory guidance on the updated RO and RME withdrawal process will also accompany the implementation of the changes. Now that guidance, as I think alluded to, we will engage with stakeholders, teachers, professional associations, parents and carers, and we'll also look at how the guidance might support the delivery of inclusive RO and RME. So I think the national guidance here might help to allay some of the concerns that Ms Gosel has raised, which I think are quite fair in nature.
Thank you. I've got just something additional, obviously, and thank you for the clarity there. You talk about children's views are heard. I just want to kind of break it down into a scenario now at school, basically, to see if, that I'm hearing what you have said. So basically, if a child decides to basically go against what the parents have decided, a child can, because you've said their views should be heard. So those views will be heard by a teacher, head teacher, but somebody in that school. And they do have to make that decision whether that child is capable, and it doesn't matter what age they are, because one child could be capable, we heard, at the age of 13. They're much more capable. One one child could be capable at the age of 15. But again, I go back to the question that somebody has to decide this, and if they decide whether it's right or wrong, the parents may not like this. So how do you see these scenarios, even though there may be only a small amount, Cabinet Secretary, you're saying, coming through, but every individual child is different, and every child, obviously, their parents care and may want something else. So there's going to be a conflict there. That's why I played it out in way. How do you then envisage, where would the teachers, head teachers like Tess asked, how do they get that help, and who makes the decisions here? Because the parents, some parents may not like it. I mean, I know I took RE when I was younger. While I agree there's certain religious education, it does bring in certain good values, especially when people understand different religions, which is very good. But I do have to say that I do see there's a conflict. So I just want to hear that. How do you manage that practically?
Denise, do you want to come back, or do you want to take that?
No, thank you. So I suppose just kind of picking up on sort of what the bill says. So there is that presumption that a child will be deemed capable of making that, and unless there's something, you know, in the context of that child in the school and the awareness of their teachers, which would lead them to not deem them capable. So it's not like they're having to make a positive decision on, oh, is this child capable? The assumption is they are. And I suppose it's probably just worth that sort of putting that scenario in the context of the process in the school. So all of this happens through a conversation, and that's where the current guidance kind of points to already, and kind of the examples of good practice we have is parent approach the school, there's a conversation about, okay, you'd like to withdraw your child, well, let's just talk to you a little bit about what RO and RME actually involve. And some of that will maybe alleviate some of the concerns that people might have around, you know, indoctrination or being exposed to sets of views that they might not be comfortable with. And so it's in that context that we're strengthening the voice of the child in that. And, you know, I suppose in a context where there might be reason for a young person to be deemed not capable, it feels I'm slightly speculating here, just to be clear, but it sort of feels unlikely that would be happening completely in isolation of any other wider engagement between the parents and the schools around a young person. Obviously, that becomes more the case as they get older.
No, thank you very much. Thank you, Convener.
Thank you. We now go back to questions from Paul McLennan, please.
Thank you, Convener. And I want to touch a little bit more on the UNCRC, Cabinet Secretary. And I suppose the evidence session we had was more from the legal representatives rather from education sort of thing. And it's around about Article 12 and Article 14. And given it's saying, you know, how does it support compliance with the UNCRC Part 1 of the bill in terms of that? So we heard various opinions talking about Part 12 and Part 14. So that was the one part of it. The other question was around about it as well, is that because Part 1 of the Bill amends the Education Act, it would be not possible to challenge a breach under the UNCRC Act. And we heard again from legal representatives who gave evidence on that. I just wondered what your views were on that. You've obviously said you've seen the evidence sessions, but particularly about the ones where it was talking about the legal representatives.
Yeah, so I've seen the evidence that has been given to the committee. I'm not necessarily sure we would agree with that. And I think the final point the member made, I've just asked Mr McLean to repeat that point, and I might bring in officials in relation to the UNCRC and the interaction with these specific articles and what the bill does itself.
Yeah, I mean, it was Part 1, obviously Part 1 of the bill was compliance through Article 12 and Article 14. And how does that comply, given it only applies to pupils who wish to remain following an RO and RME following a withdrawal request? And the second part was around about it wouldn't be possible to challenge under Part 1 of the bill because it amends the Education Act 1980. How it would be possible to challenge a breach of these amendments under the UNCRC Act? And how, you know, come on the question would how would my children or representatives challenge a failure by a school to fulfil their duties?
Okay, so I think some of these questions are quite technical in nature, so I may defer to officials to answer on your kind of legal points. So I don't know if Sarah or Denise.
Okay. Do you want to speak? Maybe on Article 12. Do you want to speak?
Just to come back to the member on Article 12, very much an important part of what we're trying to do in terms of taking the views of the child into account. So that's the basis of this Part 1
No, I'm happy to do. So you're asking us, we have UNCRC and we have the 1980 Act, and if I understand the question you're asking, you're saying if you do this change under the 1980 Act, there are less rights for the child, or less opportunities for the child to take that matter to court, because the UNCRC Act gives us justiciable rights.
That issue was raised when we spoke, obviously, to the legal, I suppose, the legal evidence session that we took on that specific point. So where that was raised as a concern.
If the question you're asking me, I don't want to give you the wrong answer to the wrong question, so this is not your question, please tell me. If the question that you're asking me is what is the Scottish Government's position in changing the 1980 Act rather than bringing a new Act to the Scottish Parliament so that we can get a UNCRC duty biting, if that's your question, there's two answers to that. The first answer is about why are you changing the 1980 Act and not doing it in a Scottish Parliament bill. I think the answer to that, first of all, is that the 1980 Act is a very sort of special, bespoke piece of legislation that has got a sort of tapestry of very complicated things that all hang together and intertwine. And it's very important for us that in order for you to sustain and protect all of that education package that we have in Scotland and, assists us as a society, if you cut bits out of that tapestry and try and recreate them somewhere else, i.e. in a new Scottish Parliament piece of legislation, first of all, you're going to disrupt the existing package of the 1980 Act, and secondly, you're going to end up with a standalone ASP with bits of Section 8, Section 9. I understand the argument. Why are you not putting Section 8 and 9 in an ASP? Well, once you sever them from the whole on their own, they don't make much sense on their own. And if you want to bring over the other bits to make it sense, you start growing the bill bigger and bigger. And so the question you ask yourself is, what will happen to us if every time we have a bit of Westminster legislation we want to recreate, we're going to end up with a scattergun of ASPs, the Scottish Parliament Acts, with bits of legislation that have been cut out of other bits and brought in. And what we want to do is create a body of law that is accessible to a reader, that they're able to see. And if you have a scattergun and they have to try and follow the breadcrumb trail, it's much more difficult. So if we change that 1980 Act, people know that at the moment is where all of our package of law for education in Scotland is. You change that, that's where the answer is when they go, and they'll see it within that. So that's the sort of one of our primary arguments about that. The second argument, which you would have a concern about that you've raised, is if you do it like that, they can't take people to court when it's been contravened. So what's your position on that? That's a good question. That's a legitimate question. And our answer to that at the moment is we've given a lot of thought to how we respect those rights and respect the ability for people to challenge and go to court. And the answer to that really is things like the Children's Rights Scheme that's going to be published in November, which is under the UNCRC. We're doing a lot of work to implement the UNCRC Act at the moment in the Scottish Government. We also have been looking at child advocacy provisions and looking at how best we can get advocates for children to be able to bring their views and to challenge on behalf of those children. And then you've got things like the law centres, and the law centres that serve Scotland very well at the moment and currently are very good at coming and complaining to the government about what they're doing. That's their job. So those are all aspects of allowing people the opportunity to have their voice heard in those environments.
If you, just a follow-up, what you mentioned about obviously guidance or the publication coming in November. I suppose if we're discussing this now, and it was an issue that was raised by, I suppose, legal representatives talking about the bill kind of stuff, it's almost, I'm not saying it's too late for us, but it's almost if we're trying to look at the bill in a rounded picture, because again, and I take the point that the CAB Sec mentioned about it's a very small minority of people that might want to challenge that, but one or two is still too many for these parents that are involved. So I suppose the issue is, if that's coming out in November, where does that, and I know we're not too far away from that, but where does that kind of leave us in terms of looking at the bill and in terms of how they challenge that position? Because that was an issue that was raised quite a bit. So I don't know if there's anything that can be done around about that, because if we're looking at it in the round, having that additional publication or guidance might help in terms of how we look at this.
Well, so I think in terms of the Children's Rights Scheme, Ms Dawn Ennis leads on this. I think it's part of the promise. Is that right? It's part of the work is supposed to be promise.
No, it's just right. It's children's
related to it. Yeah. But it does sit with Ms Dawn Ennis, but I think the chronology of this is quite complementary to the passage of the bill, actually, in terms of it being November. We're nearly there, and we're only at stage 1. So as and when the committee see that update, they may or may not be content with it, and feel free to come back to the government and probe us on these issues, but we're strengthening children's rights to our approach there. Can I just come back to the point the member raised with Denise about the 1980 Act? Because I think this goes back to the points that were raised earlier by Pam Gosel in terms of mandating certain aspects of the curriculum. Like, if you were to open up the 1980 Act, there are lots of things you could do. We wouldn't be doing a 5-page bill. It would do, there would be big serious questions potentially asked about the delivery of education in Scotland. But if the committee is interested in this, probably not for the purposes of this bill, but in an education space, I've commissioned John Wilson, who's a former head teacher in education in Edinburgh, to lead a piece of work for us on looking at school governance, on looking at what comes next in terms of how we fund our schools after the Scottish Attainment Challenge, which is meant to come to an end. We've extended for a year, but these things need to be looked at in the round. And actually, it's Pam Gosel's parliamentary colleague Oliver Mundell who's very interested in this and how we, provide support to our schools and our local authorities. We've got 32 councils. We've heard some of the challenges that can create here today. So I think we shouldn't separate out these issues from wider considerations on kind of public service.
I take in the point that was mentioned by Denise and Sarah and yourself on that one. I think it's important. I think in terms of going back to the legal challenge, again, that's something I think we'll probably discuss after that. But taking in recognises what you're saying in that. So thanks, Convener.
Okay, thank you. We now have a question from Rhoda Grant, please.
Thank you, Convener. And just following on from that, I mean, some witnesses have said to us that Part 1 of the bill is not compatible with UNCRC because it is amending the 1980 Act. So is this bill itself compatible?
I don't think I'd be allowed to introduce it if it weren't compatible. So, yes, I just checked with the lawyers.
Okay.
Yeah. So, obviously, we'll have different opinions on these things, but that's not our understanding.
Okay, but it will fall out with UNCRC because it is amending a bill from 1980, which is out with UNCRC.
I thought the question was about compatibility, sorry.
It is about, yes, of course it's about being compatible.
So I don't know if Denise or Sarah want to come in further on that, but I've seen the evidence that Ms Grant is talking to. It's not our understanding that it is, but...
Yes, this is about whether it's compatible with the international convention, which we think it is.
Okay, but given what you've said before about the complexity of all of this, I mean, should you have been looking at a Consolidation Act that would bring it into the scope of UNCRC rather than an Act amending?
We could have. I think that's fair to say. There were a range of different areas that were considered in terms of where some of these items would sit in a legislative space. I think the committee is probably aware of this. Obviously, government's taken a decision in relation to human rights to postpone that legislation, and there was potentially another legislative vehicle that could have been used. This was the first opportunity. So I don't think I am permitted to, as Minister, sit back and allow us to wait. I think it's important that we act as soon as we are able to in that regard. So I take the member's point. There are different ways in which you could do this. We view this as the first legislative opportunity, and officials may want to say more on that, for us to resolve these issues in the way that we've done. I think committee's heard some evidence on that, but we view that for all the reasons that we've discussed this morning, we can't wait, so we need to make progress on this, and that's why it's a short, truncated bill. As I say, it's technical in nature, it's very focused. It could have done lots of other things, and I appreciate and accept that, but there will be further work happening in relation to UNCRC, as the committee will be aware.
Okay.
Okay, thank you. We're now going to move on to part 2 of the bill. Just before we move on, are members content that they've asked everything that they would like to on part 1? You can always come in at the end as well, but I'm just making sure before we're going to make distinction about on to part 2. Okay, thank you. I have a question from Pam Gosel, please.
Thank you, Convener. Cabinet Secretary, we've heard from several witnesses in this committee who were worried about this bill as a temporary and short-term solution that does not address the underlying issue when it comes to legislation being compliant with the 2024 UNCRC Act. Alongside others, Professor Angela O'Hagan from the Scottish Human Rights Commission told the committee that we are looking at another add-on with another legislative instrument adding as a sticky plaster to patch up legislation whose proposals have not been well defined in the first instance. Similarly, Fraser Sutherland from the Humanist Society Scotland said the bill documentation and the pre-bill consultation clearly show that the government does not fully understand what is happening. Cabinet Secretary, we are here to make good legislation, and the evidence have clearly stated that the bill is simply not good enough and rather another sheer example of a sticky plaster approach to fix bad legislation. So how do you respond to that, Cabinet Secretary?
So I think in terms of part two, so there have been conflicting views on this. I think it's been a kind of theme that's run through the evidence session the committee's had. And I hear the members cited evidence from Fraser Sutherland and also from, I think, the Human Rights Commission. But other evidence countered that. So other evidence I think the committee heard from Together was quite supportive of the provisions in part two about strengthening children's rights. I'm quite surprised by the Human Rights Commission's position on this. I suspect it may link to wider work in relation to the delaying of the Human Rights Bill. And while sympathetic to those points, that's, this bill in itself is needed, and I think will lead to an improvement in terms of children's experience of their rights in education, which I thought the Human Rights Commission would be supportive of. But let's go to the purpose of what we're doing here. We are trying to stop a situation whereby a public authority is forced to choose between two statutory duties. So either they breach the compatibility duty or they breach another legal obligation. So in practice, this essentially means that a public authority could pause or could stop delivering a vital service to avoid them acting incompatibly. So we're not aware at the current time of any legislation that would require incompatible action, but what we're trying to do is future-proof our legislation here and make sure it doesn't happen in the future. So it does future-proof the frameworks, but it also recognises that only the courts can determine whether or not legislation is compatible with UNCRC requirements. So I hear some of the critique, but I think we need to balance that with the opinions that were heard from other stakeholders on these topics.
No, thank you for that, Cabinet Secretary. Obviously, you did say that the word balance. So can I ask, I'm sure you spoke to stakeholders, and have you had a chance to speak to these people? Because they were very, very concerned in relation to the sticky plaster approach. That was something that they brought up, and hence why today I'm bringing it up, because all evidence taken in this committee, we have to listen to whether it's good or bad in relation to your the law you're putting forward. But however, we need to make sure that have you listened to their concerns?
So I've engaged directly with the Humanist Society, and I'm more than happy to sit down with Angela O'Hagan. I've been quite struck by some of the evidence that's been provided by the Human Rights Commission, and I'm more than happy to engage with them on these topics. I think that's a sensible route. And what I've been trying to do throughout all of this is to find that pragmatic route through. You're never going to appease everyone on some of these issues because they're quite challenging issues by their very nature. But we've got to try to chart a course here for all the reasons that I've set out. So part one, I think we've now discussed, but in terms of part two, this is about future-proofing where we are, and I'm happy to engage with those stakeholders that Ms Goldsworth mentioned to, but I've also already engaged with a number of stakeholders that the committee's heard from.
Thank you, Cabinet Secretary.
Okay, thank you. We now have questions from Rhoda Grant, please.
Yeah, just following on from that question, and where Cabinet Secretary has stated quite clearly she isn't aware of any Act of Parliament that requires incompatibility action. And given the concerns with Part 2 of the bill, is it really necessary, given that you don't believe that there is any Act that would require Part 2, but yet it seems to water down the rights of children?
So we think it is necessary for the reasons that I've set out. And in terms of the rights of children, again, I suppose I go back to some of the points that I think Together made to committee. They view this as an opportunity to strengthen children's rights, and they're broadly supportive of it. So I take the member's point, but we do think that it's necessary because of the compatibility duty and the potential that a public authority, like a council, for example, I'm careful not to give direct examples, but I'm in discussion with officials trying to think of things I can provide the committee with, but it's difficult to give an example specifically. But we need to think about whether or not a local authority might withdraw or pause a service because of that incompatibility duty. So what Part 2 does is put that beyond doubt in terms of responsibilities, and it future-proofs the frameworks as they currently are. We think it is a requirement that needs to be undertaken, And I appreciate there have been some concerns raised on Part 2, although I think from the evidence I've seen to committee, fewer concerns on Part 2 than on Part 1, but there have also been some that have been quite supportive. And I'm happy to listen and to engage with the stakeholders. Ms Gosal's referenced 2 of them there, who I have already met with in terms of the Humanist Society, but together as well been very supportive of Part 2. So I'm more than happy to listen to stakeholders about how we might strengthen the kind of provisions there under children's rights, but we do view this as a requirement at the current time.
But you can't give any examples of why, where it would come into play.
Well, I might defer to the lawyers on this because I need to be careful as Cabinet Secretary to give explicit examples. So I don't know if the lawyers want to give examples or if Lewis wants to provide examples.
I think the main thing about this exemption is, as the Cabinet Secretary said, it's about future-proofing. So our position is that there is no legislation that is currently incompatible, and we also have steps in place through the Act to make sure that no future legislation is incompatible. But the UNCRC is a living instrument. Court interpretations can evolve over time. So there is legislation today that could be deemed compatible, but in 5 years' time and a year's time could be deemed incompatible due to evolving interpretation. So that could be relevant to any piece of legislation that's caught by the UNCRC Act, whether that's access to health services, access to education. A court could come along and say, we now think that legislation is incompatible, and that has knock-on effects. So it's in those very specific circumstances that this exemption would apply. It is about future-proofing. As I say, to reflecting as well on the Human Rights Act, a similar exemption has been in the Human Rights Act, and that has worked effectively for over 20 years. It's long been understood as necessary to avoid public authorities being penalised for essentially following law that they have to follow.
So are there examples where this has been used in the Human Rights Act?
We did look into that. There isn't I'll maybe bring my legal colleagues in a second. There isn't a wealth of case law on this, but we could perhaps look into this and provide examples. And that's due, as I say, there's not a wealth of case law. I think that's to do with the fact it would only be used in such limited circumstances, but due to the potential disruption of essential services and the risk to that, even though it's only in limited circumstances, we do still think it's essential.
So it could be a process that might relate to children's hearings, education or healthcare. So the exemption essentially allows public authorities to continue delivering those services while the other potential incompatibilities are looked at. And if they're needed, they will be resolved at a legislative level. So it's extraordinarily technical in nature. It is about future-proofing the legislation as it currently is. And I think to Joe's point, the UNCRC is a living, breathing piece of legislation, so it will adapt over time, and we need to ensure that we are responding to that accordingly, and that's what Part 2 of the bill aims to deliver.
Which has never been used?
Not at the current time, which is not to say that it might in the future.
Okay. Thank you. We now have a question from Marie McNair, please.
Thank you, Convener. Cabinet Secretary, a lot of the responses to the committee's call for views missed out question 2. Do you have any additional thoughts on whether you think the proposals for Part 2 are easy enough to understand and why the need for guidance is so important? It's vital that children, parents and public authorities understand the impact of Part 2 of the bill.
Easier to understand. I think they're extraordinarily complex. I think the committee has heard that and heard that from witnesses additionally. I think there's maybe some reflection that we can undertake in government about how we can better communicate some of these proposed changes. So I think that's probably a point for us to take away. But certainly from my reading of the evidence the committee's taken, there's maybe more in a communication space that we can be talking about. But it is quite a technical, legal piece of legislation that looks to future-proof where we currently are in terms of UNCRC. So there's maybe a communications element we can take away around about that aspect.
Sorry, I thought
you want to come in?
No, I was just also going to say to that, I guess I would reflect that they are two distinct issues in this bill, that although they both relate to children's rights, I think partly why there may not have been as much response to the questions about Part 2 is because that the education stakeholders may not have been concerned about Part 2 as they were with Part 1. So I think that as the Cabinet Secretary said as well about the communication, but I think it is to do with the fact there's two distinct issues with different stakeholders.
Thank you. It's a very technical bill, so the more guidance we can get, the better. Thank you.
Thank you. Now questions from Maggie Chapman, please.
Thanks, Karen. And just following up, really, possibly from Rhoda Grant's questions around the impact of Part 2, and given the unlikely nature of incompatibility arising, because we would hope that all bills from now on would be drafted to comply with compatibility.
Yeah.
Given that, and given the exemptions in Part 2, how does the Cabinet Secretary see this as affecting young people's access to justice? You talked a little bit about this in your letter to committee during recess, but could you say a little bit more, could you explain this a little bit more, how access to justice for young people will work following this exemption if it is enacted?
So, just kind of struck by some of the points that Maggie Chapman made. You said it was unlikely, but not impossible, and that's, of course, why we're future-proofing the legislation. I think just to remind committee about Joe's points in terms of the Human Rights Act, this is a kind of mirror image, is that fair to say, in terms of the approach that's been taken with other legislation that already exists. In terms of justice, you heard, I think, earlier on from Denise about some of the work we've been doing in terms of how we can support children and young people with access to justice. We, more broadly, we've had the implementation of the UNCRC Act 2024. We've had a kind of cultural shift, I think it's fair to say, in the way that children and young people's rights are respected. The duty to not act incompatibly with the UNCRC requirements and the ability to use the courts to enforce children's rights applies only when a public authority is delivering functions under an Act of the Scottish Parliament. But there are many functions that are devolved to the Scottish Parliament that are conferred by Acts of the UK Parliament, and therefore they're not subject to that compatibility duty. But we do want to embed children's rights as widely as possible. So it's important we have both those judicial options that I think we've already mentioned today and non-judicial remedies. That's why we're working with a number of partners to give that support, and remedies are already available, including the SPSO, specialist child law centres, children's advocacy services, and also relevant tribunals. So even when children and young people are able to use the courts to enforce their rights, we hope that this would be a last resort, and where there is a kind of concern about access to rights, that can be resolved as soon as possible. But it is worthwhile pointing to the fact we've given funding actually to the SPSO for a 5-year project to look at a child-friendly complaints process. We think that's quite important in the mix of what we're considering, and I know that's an issue that the committee has taken evidence on in terms of how children interact with that complaints service, and I'm sure members around the table will have experience of dealing with the Ombudsman as MSPs, as I do. Yeah. So having that child-friendly approach, we think, is quite important in terms of access to justice. Sorry. Yeah.
Yeah, thanks. I think you were also asking about access to justice when this exemption would be used as well, so I can speak to that. This may get slightly technical, but I will try not to. So I think one of the important points is that the exemption doesn't affect a child and young person's ability to challenge the actions of a public authority in a court or tribunal. Whether or not the exemption applies is still a matter for a court or tribunal to decide. So if a situation arose where there was conflicting statutory duties, a child in a public authority was acting under that, the child could still take that public authority to a court or tribunal, and they would ask the court or tribunal, essentially, does this exemption apply? And I think something that I would flag in the discussion around this is the strength of the interpretation obligation on public authorities in the courts. So when a public authority or when a child would challenge the actions of a public authority, the court would be looking at, has the public authority done everything to try and interpret this conflicting statutory provision in a UNCRC compatible way? And as we know from the Human Rights Act, which this is based on, that is a really strong duty where public authorities and the courts are able to change the meaning of legislation, add in words, remove words. So it would only be in a situation where that is not possible that this exemption would apply. If it was in a higher court, then the case would move on to the strike down and incompatibility declarator remedies that are in the UNCRC Act. And if it was in a lower court, there are referral mechanisms already built in to escalate it to a higher court. And I think just to flag, when the exemption applies, that is because that is a signal that it is the legislation that is the problem. It's not the actions of a public authority who are simply following that legislation. So it is about trying to redirect accountability to the legislation, which is the problem.
Thanks, Joe. I think those comments are really useful, and it maybe reinforces what Marie was talking about the need for very, very clear guidance around the interpretation. So you know, children and young people aren't forced to take that step to seek clarification of whether an exemption should or should not apply through the courts, because we don't want our young people to have to do that. We should hopefully have systems in place that deal with some of those issues before court action and court decision is required. But that's really helpful clarification. My final question is just relating to something, Cabinet Secretary, you said in your letter to us. You talked about engagement with the UK government to explore the removal of any legislative restrictions that limit the Scottish Parliament's ability to enhance human rights protections, and if there's no progress within the next 12 months, that the Scottish Government would commission a review of UK acts. Can you just say a little bit more about the rationale for that 12-month period and how those conversations are going with the UK Government at the moment?
So I might pass to Joe as it's with his team that it sits, but I think I had to do quite a lot of engagement with the UK Government on the previous education bill. We worked very well together, I have to say, in terms of sharing information and where there were crossovers in terms of devolved and reserved competencies. So the dissolution of the SQA was only possible because of that cross-government working. I would view as Cabinet Secretary that approach is applied to where we are in terms of children's rights and UNCRC, but I'll defer to Joe in terms of the ongoing work which is being led actually by Ms Dawn Innes at ministerial level at the current time.
Thanks. Yeah, Ms Dawn Innes leads on the children's rights scheme as we've set out, and that will be laid before Parliament soon and has the commitment you said. I think in terms of the engagement with UK Government more widely, that it's essentially to discuss the impact of the Supreme Court decision on the original UNCRC bill and the impact of our new understanding of the 28(7) of the Scotland Act. So that engagement is led on by the Cabinet Secretary for Constitution and External Affairs with the UK Government, given that it's not just the children's rights issue, it's about the kind of devolution settlement more generally. So I guess that is part of the rationale around that 12-month timeline, is to try, and it's obviously very detailed, it's wide ranging, goes across the devolution settlement, so it is to try and give time for those discussions to take place and to work constructively with the UK Government to see if there are any solutions where we could extend the scope of the UNCRC compatibility duty.
That's really helpful clarification. Thank you.
Okay, thank you. Cabinet Secretary, some witnesses have suggested that Part 2 is so distinct and different from Part 1 that it shouldn't be in this bill. Can I have your views on that, please?
So it does combine two pretty distinct issues, I think it's fair to say. And I think I've mentioned this previously, but we had intended to make the change at the reconsideration stage of the UNCRC bill, which I think was the point that Ms Grant was making earlier on, but that was not possible under parliamentary standing orders. It was then planned that we would include it in the forthcoming human rights bill, which, as the committee know, will not be introduced this session. So this bill is the first legislative vehicle to make the change that we think is required. So that, I suppose, covers off the answer. But I would say, while the issues are quite separate, they both do aim to give that kind of wider clarity and consistency in terms of children's rights. And we think the bill is framed as a very targeted, as the committee knows, piece of legislation to address those priority concerns within the time that's available in the current legislative programme, because I'm sure members are all aware that the time is running out in terms of our parliamentary calendar. So this is the approach we've adopted for the reasons I've set out, and the previous bills that we'd identified not being an opportunity for us to progress.
Okay. And that is us concluded. Are members content that they've asked everything that they wish to? That's great. Thank you once again for joining us this morning. That brings the close of our public session to conclusion. We will now move into private session to consider the remaining items on our agenda. Thank you.